As in multiple, new one?
Going to
Okay.
start the meeting and call it to order at 9:01 a.m. First item of the agenda is going to be roll call for members. Dr. Bedoli? Here. Dr. Bazzini?
Here.
Dr. Coble?
Here.
Mr. Daniel?
Yes, sir.
Dr. Downing? Here. Dr. Drake?
Here.
Mr. Parsons?
Here.
Dr. Kerrigan has been called to trial, and so she's unable to make the meeting today. Is there a motion to excuse Dr. Kerrigan? So the second is to review and adopt the minutes from the last meeting in October. Is there a motion to accept and adopt the minutes?
So moved.
Second?
Second.
All those in favor?
Aye.
Is the office administrative update?
Good morning, everyone. The first thing I'd like to do is introduce to you Veena Mohan, who is here with us. Veena is joining the Office of Court Administration from the Attorney General's office, where she served for 14 years, and in her capacity there she was advising boards and commissions, various boards and commissions, on all sorts of things related to administrative law, so she's a real expert on admin law. And she has also served as a public defender in a past life before the AG's office. So she has some criminal law background as well. And the way that OCA structured her position is that she'll be supporting the Forensic Science Commission 25% of the time. She has 50% of her time dedicated to the Judicial Branch Certification Commission, and then another 25% to OCA's General Counsel for various matters. So if you would join me in welcoming Veena to the team. The second thing, Dr. Bernard, under admin update is your budget. And if you take a look at that, it reflects some updates to the commission's activities. One is that it includes the portion of Veena's salary that's dedicated to the commission. We also have in the budget Jara Kennedy, who's helping to advise us as a subject matter expert on the DNA mixture interpretation suitability discussion that's happening at UNT next week. So the funds for her are in there, as well as the cost of travel of all of the folks who are coming to participate at UNT. And Dr. Coble is hosting that meeting for us, so that will be great. But we do need to fund the travel for the DNA technical leaders who are attending. So that's all reflected there. I think it would be helpful if you could approve the budget again, since we've had some shifts in the way the money is allocated.
I do have a motion to approve the updated budget.
So moved.
Second? All those in favor say aye. Aye. Opposed? Motion carries. So the next part is review and adopt amendment to revise the investigative process.
Yes, so on agenda item number 4, there's one thing actually, Dr. Bernard, for number 3, show you before we move to number 4, which is, if you recall, the Office of Court Administration IT staff is in the process of developing a database for us, and they have formally launched one of the functions of that. Lee, are you able to either show them it or talk them through it? We have an example of what it looks like here.
So we were able to launch our licensee database function. If you all have been to our website recently, if you just go to fsc.texas.gov and go to where you would normally look up where our licensees are, we have a much fancier version of where you can look up our licensees' profiles. And Maggie has the front page of what will be our future database portal here that will show all of our functions. But you can click on just the licensees now, and that's the piece that we've launched already. And here you can find each licensee's certificate, which you could not formally access in the old database. What we had posted formerly was just a spreadsheet, and kind of an archaic table of the information before. Now you can see the historical information about the licensee, the disciplines that they've been licensed in. You can get information of the labs that they were employed at. You can also use the search function that you see here at the top of the table. You can see whether they are active or inactive, where they're currently employed, the dates that they were active as a licensee. And we're really looking for feedback from the laboratories too. We got some good feedback yesterday, and we're going to take that to our database administrator and make some changes with that feedback. And if you all are interested in looking at it, I encourage you to take a look at the database and see what we've done here. We're able to do for us, given the feedback that we've given them, and we hope that everybody finds it functional and a good use of the information.
And so it's a lot easier to look up someone now, and the next part of the database will be the accreditation piece, so you can look up an accredited lab and the entire history of the lab. The next part will be moving on to the quality incidents, as we discussed, the OSAC compliance, so they're rolling out each section one at a time. But the perception was that licensee information was important. So if you click on someone's profile, you can get their licensure, their certificate. If you scroll down, Maggie, you should be able to see, if you click on license certificate, it brings it up there. So that's helpful for when people go to testify, or if you have an attorney who would like to see, you know, has this been issued, when it was issued, when will it expire? You know, what is this person's history? It can all be there. Are they inactive, active, or, you know, we don't have this often, but has their license been revoked or other disciplinary action taken? So we are moving forward with feedback from the LAC, and as we roll out each section of the database, we will demonstrate it for you all in the meeting. Does anybody have questions about that?
Yes, ma'am. Lynn, you probably know this question before I ask it. The other components of the accreditations, the compliance, disclosures, quality, what's the timetable on that? Any idea?
So the team that is developing this is back dedicated to our work full time now. So they have, I think for accreditation, I don't know if they gave you an actual timeline, Lee, for accreditation, but assuming hopefully they don't get pulled off of this to do other work, I think we're talking about, you know, weeks now, not months. But I will have a better understanding of that next week, because we're going to meet again and go over the timeline again.
Good. Thank you.
Thank you. All right, item 4.
So for item 4, we are proposing a change to the process that the commission uses to conduct investigations of complaints and self-disclosures. As you know, historically, the commission has created investigative panels that collect information from the public or from the laboratories or the affected parties of an investigation. And what we found over time is we think there'll be some efficiencies gained in having the staff do the work of preparing the investigation, conducting the interviews, and gathering documents. All that would be made available to commissioners for review. And then the commissioners will be able to review the report, offer feedback, accept, reject it, and so forth, or modify it, and then approve that. One of the reasons for doing it is to sort of ease the scheduling burden on members of the commission and make the process more efficient. And also, we are planning to integrate more subject matter expertise, like we did with recent investigations, including the Expertox matter. Now, that process allows us to really drill into the technical issues in any of these investigations. So those are sort of the efficiency reasons for making this shift. It's possible that commissioners may have legal questions about this, and Dr. Bernard has the process for going into closed session if you have any legal questions.
I think there could be some questions. So at this time, the Texas Forensic Science Commission will go into closed session pursuant to the Texas Open Meetings Act on agenda item number 4 concerning the review and adoption of the rules that effectuate the revisions to the Commission's investigative process to receive legal advice from the Commission's attorney under Section This point will be tabled. We will move to item number 5. Mr. Daniel?
Yes, sir, Dr. Bernard, today we have 5 disclosures since our last meeting and actually 6 complaints. The Complaints Disclosures Committee did not meet the day before, as we sometimes do, primarily because of the simplicity of numbers, the lack of numbers to justify a meeting. And so we're here to present these to the commission as a whole. Our first item is item 2258. It comes out of the Houston Forensic Science Center seized drug section. The lab had actually misidentified an item of evidence as a controlled substance. They amended the report to correct that information, which was discovered on December 12th of 2022. The lab originally reported the substance as alprazolam, is later identified to be 4-chlorodeschloroalprazolam. And I know Mr. Parsons is shocked that I can actually pronounce that, but I was able to.
I believe you had help.
I did. And a lot of help. And which is nothing more than a novel compound that actually is not even controlled. So the lab itself went back and reviewed all the cases from January to November 2022 and saw this as the only case that occurred. They notified your district attorney's office, and they're in Harris County. They're going to research this novel compound and determine the appropriate process to differentiate it from actual alprazolam. So their actions were extensive. The staff had studied this carefully and made a recommendation to us to take no further action based upon the corrective actions, the case review, and the appropriate notifications. And I will make that in the form of a motion at this time.
Is there a second?
Second.
All those in favor say aye. Opposed? Motion carries. Did we miss 2252?
We did, and I apologize.
Okay.
I got to overachieving there. But that takes us back to our first item, which is 22.52, which comes out of the Jefferson County Regional Crime Lab from their firearms and tool marks section. They had an analyst that actually identified a firearm reported result that was different from the expected or consensus result. This was on a proficiency test. The verifier of that failed to catch the problem also. This analyst had taken a 2019 proficiency test where he had not seen this previously. The test consisted of a set of test-fired bullets with a known item and then 4 bullets from the crime scene with victims. 1 bullet was identified as the known. The other 3 bullets should have been eliminated from the known. However, the 2 question bullets should have been identified as having been fired from the same unknown gun. The analyst correctly identified the 1 item and eliminated all the others, and he incorrectly eliminated items 2 and 3. In its corrective action, the lab had determined that part of the root cause was poor markings actually on the bullets as being incorrectly eliminated and marked poorly. They also saw an expectation bias present. The lab shut down and halted all their comparison casework at that time. The analyst, one had 11 years experience. The verifier had, I think, 4 years, and they had never been found to engage in similar behavior. The lab's policy clearly permits for inconclusive conclusions in the proficiency test, but the added language to ensure a full range of conclusions that can be expected in a proficiency test. They also gave the analyst a second open, non-blind proficiency test made up of parts of past proficiency tests designed to challenge his abilities. He correctly identified and eliminated all those expected items. And they're working to incorporate more blind proficiency in their firearms program. So what happened. Staff had reviewed the matter carefully. They had brought forth to us a recommendation of no further action based on the corrective actions, the extensive casework review, the changes in lab policy, and also anticipated changes in their proficiency testing program. I concur with that, and I can make that as a motion this time. We take no further action.
Mr. Daniel, I'm sorry, could I interrupt really quickly? So some of the issues that you'll see in 2 proficiency testing, firearms-related matters will be covered when we issue the report in the Nane and Williams matter, because these are all pressing issues within firearms analysis. The trouble with inconclusives is actually the title of a talk that Dr. Bedoli and I will be giving at the Academy meeting because of this issue with the inconclusive results in firearms not being well understood by the end users of the firearms analysis. That is a problem that's been there for a long time. And then secondly, how proficiency testing is done, the extent to which a lab, especially a small one, is able to incorporate a blind proficiency testing program. Like HFSC has done that. It is widely regarded as one of the best initiatives that any forensic science service providers have engaged in the country. There are articles written about what HFSC has done. But if you're a smaller lab like Jefferson County, it would be very hard to do blind PT without help. And so I think it would be really fantastic if the commission could consider how to help what has been done at HFSC for blind PT, how to help expand that so that other labs in the state, regardless of size or resources, could participate in that process. And I feel like it would be well received at the labs. There are a lot of things that people would like to be doing, but then the question is, well, how do we implement this? We have 2 qualified firearms analysts, and it's very hard in that setting to be able to integrate these sorts of initiatives successfully. So that's all. I did want to make that mention.
So the motion would be to take no further action.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Which brings us to our third item, which is 23.01 from the Fort Worth PD Crime Lab. Again, their firearms and tool marks section also. This also will be addressed in the Nane and Williams report at some time with regard to inconclusive results. The firearms section, the analyst reported 3 inconclusive results on external proficiency test, in contrast with some expected consistent results. The expected results were 3 exclusions and 1 inclusion. The analyst, however, reported 3 inconclusive results on 3 items, 2, 3, and 5, and 1 ID on item number 4. The lab notes that the report states that approximately 6.7 of the respondents submitted inconclusive as a result for the items 2 and 5, and 9.4 submitted inconclusive. In response to this, the Quality Assurance Director conferred with the firearms supervisor. They felt like there was some impact of this with regard to the analyst's previous training from California Department of Justice, and they had a policy that dictates analysts will not make a conclusive determination if subclass characteristics cannot be excluded as being present. By way of analysis and corrective action, the lab acknowledged that if the analyst is reporting inconclusive on cases where the truth is exclusion, that can become an exculpatory evidence issue. They described this area as some type of false negative. The lab misunderstood that depending on the facts and circumstances, a missed exclusionary result might impact case outcome for a defendant the same way as a false positive would. They're presently looking over 35 cases done by this analyst back in the calendar year 2022, and even cases worked by her before that after the proficiency test to evaluate whether other casework might have been affected. We're still waiting on that. Their relevant policies and procedures will be revisited by the lab to see if additional clarification can be made and additional training may be necessary. They want to discuss with the commission a little statewide working group. I don't know that we have jurisdiction to do that on this item, so we don't need to worry about that. But staff had recommended no further action, conditioned on a couple of things. One, receive the outcome by the lab and the additional policy modifications if it's necessary. And again, as we said, that will be also addressed in the Nane and Williams complaint. So I would at this time make that in the form of a motion to take no further action.
All right, is there a motion, second on this?
Second.
All those in favor say aye. Aye. Motion carries.
Our fourth matter also comes from Fort Worth PD, and I'll go ahead and begin by telling y'all I think this would deserve to be tabled. It's a Worth Crime Lab, an incident where their laboratory discovered purportedly a loss of data from its quality management system when a former interim quality assurance director allegedly deleted or discarded some laboratory data as she was leaving her employment with the lab. Their forensics units tried to recover the lost data, but was not altogether successful about it. Their corrective action documentation was provided to us and all the respective parties as soon as it becomes available. I think we're waiting on some more information on that and a formal corrective action document. So this is far from complete, and at this time I would make a motion to table this matter.
Before you all consider the motion, I just wanted to say that we did receive additional information from the laboratory about what types of documents did the laboratory through its reassessment that ANAB did recently. That is another agenda item on agenda. ANAB, we let ANAB know that this allegation has been made, so it's pretty serious, and I think we really need more information. ANAB is in agreement with us that it's very hard to do anything with this until we know more information, and we haven't had time to even vet the most recent thing that we received from the lab. So we don't know if it's lab data in terms of, you know, what's in the limbs, or if it's quality data, or to what extent. So we really need to hold off, I think.
All right, motion's been made to table. Is there a second? All those in favor say aye. Opposed? Motion carries.
Which brings us to our fifth item, is item 23.03, the Barrow County Criminal Investigation Lab, their seized drug unit. They had an analyst misidentify a substance they tested as methamphetamine, even though the case notes indicated it was heroin. The actual substance itself identified correctly as heroin during a physical analysis, and the analyst simply misreported it. They had said due to clerical error or oversight by the analyst. As they set about to figure out how this happened, there were references to the fact that some of the workspace was messy and didn't have adequate workspace, which contributed to some failure by the technical. Not real sure about workspace issues, but they've since alleviated some of these workspace issues, and they've gone to more of a paperless system. They also found that technical reviewers not always reviewing as thoroughly as possible due to two issues. One was fatigue based on large volume of cases assigned to each analyst, and then pressure for a faster turnaround time, which sounded to me more accurate than workspace issues. And they're seeking to reduce the assigned cases and reviews from about 21 to anywhere to 12 to 15 cases per batch, which should help that. The lab issued an amended report in the case. They also disclosed the issue through its ethical disclosure unit, which included a notice to the assigned prosecutor in the case. They've done what they can do to correct it. Staff had vetted it carefully and brought forth a recommendation, no further action, which I concur with. In light of the corrective action, also changes implemented by the lab, including an amended report. And so I'll make that in the form of a motion that no further action needs to be taken.
Any discussion? All right, is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Which Dr. Bernard will take us into our complaints. Our first complaint is a holdover from the October meeting. It's item 22.40. It's from Meet and Negatory Promotional Practices. The commission had requested an update from the Office of Inspector General at the last commission meeting. We're still waiting on that. I know many of you probably feel this is more of a personnel or HR issue. There's some suggestion it may have some implication on quality of lab work. So rather than dismissing it, let's table it until such time as we get that final report and see if it even fits within our jurisdiction. So if there aren't any questions, I will make a motion to table at this time, pending the completion of the Inspector General report from DPS.
Mr. Daniel, just an update on that. We did reach out to the OIG because this report was supposed to be ready in January. We haven't received it yet, but I do think it's definitely going to be coming very soon. And so we should be able to resolve this at the next meeting, depending on what that report says.
Motion table.
Is there any discussion? Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Dr. Martin, next matter is 22.45. You may want to recuse yourself.
I
It has
do.
an allegation with Swifts. It comes from Tommy King. It's a complaint against the Dallas Police Department Forensic Biology Unit. We had previously addressed a complaint from him back in 2022 of multiple assertions that contradict the record. This matter alleges blood evidence on a knife involved in his case had been deliberately planted by a Dallas detective involved in the investigation. Staff had recommended dismissal on the basis of failed to allege some professional negligence or misconduct. We don't have any jurisdiction over a peace officer allegedly planting or fabricating evidence of any kind. In that respect, there aren't any questions. I want to make a motion to dismiss at this time on that basis.
Do we have any discussion? Do I have a second?
Second.
All in favor?
Aye.
All opposed? Okay. Motion carries.
Which brings us to our eighth matter. It comes from Richard Highland. It's a complaint against DPS down in Corpus Christi, their blood alcohol matter. Sadly, Mr. Highland was involved in a motorcycle accident. His wife had passed away as part of the accident. His blood alcohol concentration had been logged at 0.19. He had been convicted and received a sentence. His complaint was that the alcohol testing of the blood was not, there's no video of that. There's also no video of the extraction of blood from him. Staff had reviewed the matter carefully. They recommended that we dismiss the case because it really doesn't allege professional negligence or professional misconduct related to some kind of physical forensic analysis. No video footage of blood extraction and no testing doesn't equate into professional misconduct or professional negligence. So if I would make that in the form of recommendation that we dismiss this matter.
Any discussion? Is there a second?
Second.
All those in favor say aye. Opposed? Motion carries.
Then we come to our ninth matter. It comes from Mark Rodriguez. He alleges in his conviction for aggravated assault it rested on purportedly faulty and discredited unreliable mixture profiles from two individuals in the genetic evidence. The complaint alleged that evidence from the crime scene was, quote, probably contaminated. It also alleged certain evidence was never tested. It was hard to tell exactly what he was asking, but the ultimate request was the commission asked the convicting court to go allow retesting and testing for biological evidence, which is something he can do in a writ. Staff looked at the appellate opinion. Rodriguez was not excluded as a contributor on two items of evidence. Staff obtained the actual DNA reports from the lab, and the lab conducted analysis in 2018, including StarMix, probabilistic genotyping software, and it looked to be a confirmation and hit. So I would, staff had recommended that we dismiss the complaint. I will make that in the form of a motion.
Is there any discussion? Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Which brings us to our 10th item, which also involves SWIFT. Dr. Bernard, you may want to consider recusal on
I do.
this. Okay. This comes from Arthur Henderson against the SWIFT's toxicology report that he claims was an error. He provided with his complaint an affidavit, own expert Henry Bunnell. It alleged various issues about the autopsy report and findings, including medical significance of some postmortem blood tox results. The affidavit contested findings in the autopsy report and also alleges some toxology findings that alone were sufficient to cause death. You have to kind of split this. First off, the medical aspect of it, we don't control that as a Forensic Science Commission. And then when you look at the complaint about the toxology results, its forensic analysis really didn't include a portion of the autopsy conducted by the medical examiner or other forensic pathologists. And it didn't say the toxology was flawed, but simply disputed the implications as it pertained to the pathologist's conclusions. So both are sort of outside of our lane, and for that reason, staff had brought forth to us a recommendation of dismissal, and I will make that in the form of a motion at this time.
Do you have any discussion at this time? Do we have a second? Second. All in favor? Say aye.
Aye.
All opposed? The motion carries.
And then the 11th item comes from Linda Cowan in against the Capillary DPS office involving firearms and materials being traced. They were looking at a projectile recovered from a pillow at a crime scene. It was a fragment of the bullet. It was reportedly not recovered by the police until the firearm was rendered operational, and was so distorted as to be capable of normal measurements, contained only blue and white fibers consistent with the pillow, and instead of additional trace evidence consistent with screen, glass, hair, and skin, which they say it passed. In other words, she's saying this should have had hair, glass, and skin on it. The complaint also alleged some GSR testimony insinuated gunshot residue on a pair of pants, despite only 2 indicators. When you look at the testimony submitted in the complaint, it indicates this projectile was a .22 caliber projectile. It could not be identified or eliminated from being fired from that weapon due to all the corrosion of the rifle barrel. The examiner also testified the failure to recover glass fragments embedded in the projectile did not necessarily mean it didn't pass through those kind of items. So as far as the gunshot residue, the analysis of the pants identified 2 complete elements indicative of gunshot powder residue, and the complaint that they couldn't exclude because of some auto repair work could also produce a similar particle. So the complaint really does not allege some forensic negligence or misconduct related to the analysis in the case, and the allegations regarding incomplete and accurate testimony really weren't supported by what was provided to us in the record. With all that being considered, staff had recommended we dismiss this matter, and I concur with that, and I'm prepared to make that in the form of a motion to dismiss.
Mr. Daniel, one thing I wanted to correct is that it is DPS, but not the Capital Area Lab.
Sorry.
It's the Austin Lab. That is an error on our part. I just want to correct the record. The Capital Area Lab does not do this type of analysis. And also, I'm not sure that we were clear in the memo, but Robert Smith did review the testimony of the individual at DPS in Austin who performed the GSR testing, and he was clear that there could be similar particles due to contact with something like auto mechanic type work. So that was all presented in the course of the testimony.
Okay, so was there any further discussion? Is there a second?
Second.
All those in favor say aye. Opposed? Motion carries.
And then, just to ensure that the record is clear, in our interim since our October 22 meeting, staff had administratively dismissed 6 complaints, which we have authorized them by public action to do a few years back. The items dismissed were 22.48, 22.55, 22.56, 2257, 2259, and 2260. All of those were clearly outside the scope of the commission's jurisdiction. I just want to make sure we give blessing or approval to that. Why don't I just go and make that form of motion that we give our approval to the staff dismissal?
Any discussion? Second? All those in favor say aye.
Aye.
Opposed? Motion carries. Next is item number 6, which is the status of the Crime Laboratory Accreditation Program.
Thank you, Dr. Bernard. I sat back down because before I couldn't see Mr. Daniel because the camera was blocking him. But if you prefer, I can stand at the podium, whatever you all prefer, I'm happy to do.
We're good.
Okay. So the accreditation memo this time, as you might notice, is quite extensive. There was a lot of accreditation activity, both in the form of reassessment, surveillance visit at DPS, which is always, anytime there's accreditation at DPS, it's a massive undertaking for all involved. There were a couple of things that we wanted to point out to you. We did do quite a bit of follow-up with the laboratories on various issues that presented themselves. For example, Bexar County is the first one on there. The assessor had raised concerns about their validation of THC quantitation. We went back to them to try to get a better understanding. The concerns were not so much about the approach to validation, but rather how it had been documented. And so they revamped how they wrote up their validation to meet the requests of the assessor. We do have a couple of items that will stay outstanding for now. One is with Texas DPS, you'll see that they had an accreditation nonconformity relative to a missed PT for 2 DNA analysts in Houston based on a misunderstanding of the technical leader on the timing of the PTs under the QAS. The reason that we asked for more information on that is because, and I'm saying this for the benefit of everyone watching and everyone here, if you have an error in proficiency testing that ANAB or A2LA picks up as a nonconformity with their requirements for PT, one of the things that the laboratory needs to look at is whether or not they made a representation to the Forensic Science Commission that PT had been complied with under accreditation standards. Because if then the accrediting body comes back and says, no, your PT is out of sync with what our expectations are, you really need to go back and look at the timing of what you certified to the commission for licensure purposes, and then if a correction needs to be made there, make the correction. So that's just something we wanted to point out, and I know that DPS, they have an entire corrective action on the PT being missed, but nowhere in there does it discuss potential impact on licensure. So it's just one thing to keep in mind. It's entirely possible that they cured it before they made that representation, but labs should keep that in mind, because then you have sort of a double nonconformity. You're not, you have your PT nonconformity, but then there's the rule that you have to be in compliance with your local regulators. And that's under 5.4 of the ISO standard, which ANAB certainly will cite too. So there's that. The other issue that was raised in the assessment was the mixture validation, DNA mixture validation that was done in Houston. And they are still in the process of working on the quality incident and corrective actions for that. So that's something that we're going to be paying attention to. And we will give you an update at the next meeting about that. The U.S. drug testing laboratories, you will see, they have many nonconformities that were significant in nature, and so we've asked for follow-up. We just got that yesterday. Lee has not had a chance to look at it. And then the last thing I wanted to raise with you all is that we have some laboratories that are accredited. They're all private laboratories. They're accredited to ANAB or A2LA standards, but what we've noticed is they don't have any licensees. And so what we're trying to do is figure out a way to distinguish the laboratories that don't have any licensees. They need to be licensed under law. The explanations that the laboratories have given us is the following. We're private labs, we respond to requests for proposal for testing. Oftentimes, though, RFP documentation has in it a requirement that the lab is accredited under Texas law. But what they're saying is, so we need that in order to be able to submit the response to request for proposal. We will license our people if we get the contract. If we don't get the contract and we're not in Texas, then why would we go through all of that? Because we may never be there if we lose this RFP, if we don't get granted the RFP. So I feel very strongly that we need to signify to the public to distinguish between those labs that are accredited but not licensed and all the rest of the labs. You know, from a certain standpoint, as a business issue, it makes sense what they're saying. But we don't want people to be under a misunderstanding when they go to our website and think that, oh, I can just have them start work. No, they have to get licensed under one of the licensure programs. Does anyone have any questions about that? Does that make sense to y'all? Okay. That's everything. Under the first point for accreditation memo, the second thing we wanted to talk to you about is that you have a rule before you that essentially phases out ABFT accreditation that will no longer be available. They're no longer accrediting, but what they're allowing is that the labs that are accredited to that program can finish their current cycle, and there's no more opportunity for extension, renewal under that program. They all have to transition to ANAB, which is administering the ABFT standards. We reviewed all of our labs. There's only one that has not made that transition yet. It's the Travis County ME's crime lab. So we sent a letter to them, which is in your materials, that Dr. Bernard signed, advising them that they need to move with all deliberate speed toward ANAB accreditation and that there will be no extensions. So we suggest that they get that done without leaving it till the last minute. So you can see that in your materials. Does anyone have questions about that? We do need a vote for the approval of the rule.
Yeah, so is there a motion to the 37 Texas Administrative Code Section 651 relating to the final transition of the American Board of Forensic Toxicologists accreditation program to ANAB? Is there a second?
Second.
All those in favor say aye. Aye. Opposed? Okay.
Dr. Bernard, when we make the motions for these rules, they should be a motion to propose the rule, not to adopt it, because it has to be proposed, it goes out for public comment, it comes back, and then it's adopted.
That sounds very much like a lawyer, sort of. All right. Do I need to redo it?
Yes, I'm sorry.
Okay.
Could you please redo it? Thank you.
Is there a proposal to accept the amendment to the 37 Texas Administration Code 651.4 regarding the final transition of the American Board of Forensic Toxicologists accreditation program to ANAB?
So moved.
Is there any discussion? Second?
Second.
All those in favor say aye.
Aye.
Opposed? Okay.
And then the final thing that we wanted to report is that, as you might recall from the ex parte Cologne matter, the commission had issued some recommendations of general applicability for the labs, and those will be assessed. We've spoken with both ANAB and A2LA about that process. They are on board for that. We've worked through some checklists that the TAFQAM has been very helpful in developing. They are going to assist with establishing some expectations for what constitutes compliance, and they will be making recommendations to staff as they consider how the labs are implementing. So we feel like that's moving in the right direction, and we'll continue to work with them on that. That's everything for the item number 6.
Yeah, so item number 7 is the discussion of the Licensing Advisory Committee update.
We have over 1,200 licensees currently in the program. It was a big lift at the last 3 months of the year to get everyone licensed. We are going to transition expiration dates to work more like the state bar works, where your expiration is tied to your birthday, so that it doesn't all come in at once. The reason it all comes in at once now is because the legislature said that the program needed to be implemented by January 1 of 2019, so we got everybody licensed, and now we have this problem where every 2 years we have 3 months of very intense demand on the staff that doesn't make a lot of sense. So we're going to work on how to transition to birthday connected expirations. And I feel like the labs will probably also appreciate that, because it keeps things a little more moderated. So we will give you updates on how we plan to do that. We did have one nonconformance. The Plano PD let us know that one of their licensees in firearms had not received the notice that he needed to update his license to renew it because it went to an old email address. So we were able to work with them to get that resolved. We put before the LAC the final version of the voluntary license programs in digital evidence as well as friction ridge analysis. One of the things that was raised in the meeting yesterday is that the friction ridge OSAC documents that we were discussing have moved into what's called the SDO process of the OSAC, which makes them a bit of a moving target. So we're going to be discussing with the LAC how one can implement any licensing program tied to registry standards when really they are subject to change at any time. So we're going to be working with the LAC on a proposal about how to do that at the next meeting. The reason why we have anything related to OSAC on there at all is simply because when we gathered subject matter experts together, such as Henry Swafford and Jack Flanders from Texas DPS and others, they said that those standards, at least in Friction Ridge, it's not universally true, but in Friction Ridge, there are some good quality standards that move the community in the right direction, and it would be one metric to use since most Friction Ridge providers are not accredited. So we'll be discussing that more. We've transitioned fully to the General Forensic Analyst Licensing Exam, number 2, the second iteration. We've also transitioned fully to remote proctoring, and I want to spend just a moment on that. The remote proctoring is done through the Blackboard system at SHSU using a software provider called Respondus. It's a lockdown browser. It's used, any of you who are affiliated with academic institutions, you know what I mean. You sit at the computer, it makes you take your laptop all around your body, under the chair. If you're taking the test and your dog walks by in the background, it alerts that there's an anomaly with the test. It's designed and it helps in university systems where there are large numbers of students taking exams. One of the reasons why we introduced this software was because without it, the laboratories needed to assign a physical proctor that would have to be in a space and sit there the whole time everyone was testing. We had some people testing out of state during the pandemic, working in remote environments. They couldn't get into the lab for health reasons, so we wanted to give them the ability to have remote proctoring. We thought that was all going to be great and everyone would be happy with it. The problem is that the Respondus lockdown browser is apparently a huge red flag for the cybersecurity divisions in any law enforcement agency, or they have to go to the county IT department, but the IT department takes it to a whole committee that is looking out for cybersecurity issues in Bexar County in general. And he said that process, we're not talking about weeks, it's like months of sitting and waiting, and then it's to get it done is a serious challenge. So listening to that feedback, and I don't think that they're the only lab that's had challenges with it, we're going to be discussing how to offer people more than one option to pull the Respondus off. We liked Respondus because it's very secure In the settings where people are able to put it on their computer, it's extremely effective and it works well. But for some of the labs where the IT oversight is very heavy, it's been a real challenge. So we need to reconsider that. We thought it was going to be a great tool, and it is to some extent, but there are challenges there. Do you have anyone have any questions? Okay, so we will report back to you on that.
All right.
That's everything for number 7.
Item number 8 is an update on the investigative panel from 22.17 Fort Worth PD Crime Lab and adoption of the final report.
We will not be able to adopt the final report today, Dr. Bernard. If you recall, that matter was reviewing significant issues with proficiency testing in the laboratory, including that some analysts were taking PT after the consensus results had already been published, and ANAB raised concerns about that. There were also issues around weighing events and measurement uncertainty in the seized drugs section. All of these things were covered in the laboratory's reassessment. There were issues around the laboratory's training and technical records, miscalculation in blood alcohol that actually was something one of the assessors asked a blood alcohol analyst to come in and show a recent report, and in that process she made a miscalculation. So now that triggered questions about whether this was just a one-off thing or whether it's a calculation problem in general. So all of these things we were hoping to resolve in the form of a final report. And then we got the disclosure that says that the interim quality manager who helped them get through the reassessment deleted records. So we have to figure out the scope of what that is, and ANAB is asking the same questions. That is where we stand with that.
Okay. Item number 9 would be an update regarding Expertox, but I believe we're going to pass on that
Yes,
item. It's still being negotiated, and there's nothing for us to consider at this time.
correct.
Right, item number 10 is an update regarding complaint 21.27, the Innocence Project on behalf of Nannon Williams.
So in that matter, we are waiting on NIST's foundational review in firearms. That should be published anytime. In the interim, I've been looking at the research that's often cited for questions around firearms, particularly in inconclusives. If you recall, David Kay presented us with a memorandum that he and his law clinic from Yale worked on, with some observations around reporting of firearms results. I've looked at the FBI AIMS studies sort of in preparation for drafting of the report. And so we will have something for you, my hope is in April.
Okay. Item number 11 is an update for self-disclosure 21.72 Brazoria County Crime Laboratory and Toxicology.
So I would direct your attention to the proposed report that you have in front of you. Essentially, there was a major transition in leadership. The former lab director, who was with Brazoria for a long time, retired, and a new laboratory director came on board. He is present with us today if anyone has questions. What they found out was that the laboratory was having some issues in complying with their own SOP around blood alcohol analysis. What the SOP stated was that individual case samples from triplicate injections that they were running, which is not typical to run things in triplicate, but they were. The rule internally they had said that the results must agree within 10% of each other, and if the analyst observed greater variation than 10%, the results should not be reported out. They needed to rerun those results. A different provision of the SOP said that an analyst, so what you're going to have if you run it in triplicate are 6 data points emerging from that. And there was another provision in the SOP that said they could consider only 4 of those if they wanted to, in assessing whether that 10% agreement rule was met. But the SOP provided no guidance on which data points they could disregard. And so what ended up happening in a lot of these cases is that the analyst was disregarding the outlier data points in order to achieve that 10% agreement. And that's not a supportable practice. You don't disregard outlier data in science generally. So the lab director who came in picked up on that, understood and appreciated that that was what was happening, and they also noted that there were issues with truncation of results. They were supposed to truncate to no less than 3 decimal places, but when the result of that analysis about agreement was right there in the 10 to 11% mark, they were not following the truncation rule. So that would get them to 10%. And these were all things that the new lab director picked up on. They went and looked at what cases might be impacted by this. It was 42 samples comprising 41 cases. The final report lays out what the results of their review of all of those, what the results were. And they did send 2 different groups out for retesting, one to Quality Forensic Toxicology in San Antonio, another set to Texas DPS. Part of those have already been worked. Part of those they're waiting on guidance from the DA about. In those cases, some results came back with a lower BAC and some came back with a higher BAC than what Brazoria had originally reported. All of this information was posted publicly on Brazoria County website set up for this matter. I went and looked at that in the process of preparing this report for you. They have not only the cars related to this matter, but all of the cars that they have done since the new administration, the new scientific leadership took over. So they're using that website as a way to keep the public informed of all of their quality events. So in terms of the investigation, the staff reviewed extensive documentation, many spreadsheets with various data in there. Dr. Kerrigan assisted with that. We interviewed the lab director as well as the quality manager and the head of the toxicology group who announced his retirement, so he will no longer be with the lab. If you see in the findings, there's no finding of professional negligence or misconduct associated with this. There were additional things that the lab director identified as he was looking at all of these issues. One of the biggest concerns, I think, for him was what he observed in the analysis of drugs in blood. So not blood alcohol, but the drug stuff. So they do 5 different types of drugs: cocaine, benzos, opioids, THC, and methamphetamine. And what he was seeing is that the laboratory would perform an immunoassay and then using retention times from GC, make a decision about how to identify the drug. But if the immunoassay came back negative, they would issue results from the GC retention times without doing a separate independent test. And so the issue there is that that is insufficient to be able to report these results out, because you have essentially then you're relying on one thing, which is the GC retention time. So they stopped doing blood drug testing immediately once he realized that. The other important point to note is that that method applied to all five controlled substances. So there was no variation in methodology or approach depending on what it was they were testing for. So we suggest in here, as we wrap up the report, that they should identify any cases affected by the inadequate drug tox method and take corrective action if they need to. I think it may not be that the results are any different, but rather just that what they needed to do to get to those results is much more than what they were doing. The other thing that Dr. Kerrigan pointed out and that the lab management agreed with is that sometimes if you see this variation frequently, where they can't get that 10% agreement, it might be attributable to pipetting technique. And so she really encouraged them to think about that, how they're going to approach training around pipetting and what they're going to use. I think there were some changes made in the materials that they use for pipetting. ANAB did not pick up on either the issue with the blood drug or the 10% variance. So we have sent it to them, asking them to take a look at it, because one would think, I guess I could understand for the blood alcohol, there was some confusion in the SOP itself, but for the drug tox methodology, it seems like they should have known that that was an insufficient way to test for drugs in blood. So we'll wait to hear what they say. One of the things that the lab director brought to our attention is that the employees that he took managerial responsibility for when he was appointed, a lot of them felt like they weren't able, with the former lab director, to freely raise questions and concerns. So the new lab director has an open door policy with respect to that. We have a point in this report about the importance of the laboratory having sufficient resources to do the work it needs to do. They need both human resources, instrumentation, and support for training. If those things aren't present, it's really hard for the lab to fulfill the needs of of all the partners in the criminal justice system. So we have a point about that. And also, they only have 2 seized drugs analysts right now. They're not doing blood alcohol. They're not doing drug toxicology, because the lab director shut all of that down when he found these issues. They are doing seized drugs. They have a backlog, 2 qualified analysts, one of whom is the lab director. So how a lab director is supposed to do bench work, tech review, and run the lab and stand back up the blood alcohol, it's impossible. So really, this is sort of a call to local. We don't have control over local funding, but it's important that the lab be supported. The other thing that the new lab director is really intent on is ensuring that whatever methodology they do incorporate will follow national standards, including OSAC registry standards. If you recall, the FBI has given permission to Mark LeBeau to help evaluate laboratory efforts to comply with OSAC registry standards. So Mark's first project, when we integrate him into this process, which will hopefully be soon, will be to help Brazoria with their policies and make sure that they're compliant with the intent and the language of the OSAC standards. We don't have any universally applicable recommendations here for the assessment checklist. We think a lot of these things were specific to Brazoria. So that is the end of the report. We do have representatives here, or we did. Hey, did you want to add anything, Derek?
No, I think you pretty well covered everything.
Okay. That's all that we have for Brazoria.
Is there any further discussion? Do I have a motion to adopt the final report?
So moved.
Second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries. All right, item number 12 is an update on the investigative panel for complaint 22.16, Joseph Webster, and the Ron Smith and Associates Leighton Prince.
Yes, sir. My microphone is not working. But this complaint involves a bloody print that was photographed at a crime scene and analyzed by Ron Smith.
Robert, I'm sorry to interrupt you. Would you mind coming up here just so that the audio can record?
All right.
We can hear that.
This complaint involves a bloody print recovered at a crime scene by a photograph, and there's challenges to that identification that was made by Ron Smith. And we have received information that the original image that the defense expert reviewed, his name is Henry Swafford, he did it for the Harris County PDO, he was looking at an image that was of poor quality. It wasn't a quality reproduction. So we've undertaken to reproduce everything in that file. It's an extensive file. You know, lots of people were compared to these prints. And the Houston Forensic Science Commission laboratory agreed to do that. There's a nice lady there named Rebecca Green, and they just finished the reproduction of all those materials. We received them this week, and so that's going to our expert that was retained by the commission, Glenn Langenberg, and he's going to review that, and then we're going to proceed to distribute those materials to everybody, and then we're going to get going. And I think this might be done by the April meeting, but that's what the holdup has been, is just starting with the best quality image we could.
And so just to summarize the issue, there was a real question raised by Ron Smith and Associates about whether what Henry was looking at was of a quality that he could really comment on what was originally done or not done. So Glenn is very graciously agreed to take a look at that question first and let the staff know what he thinks, and then we'll take it from there. As Robert said, Rebecca Green from HFSC, I mean, it's so much information that she had to go and get from the court records. We are very grateful to their willingness to do that, even though they have all tons of pressures and getting regular casework out the door. So thank you for that, Houston, if you're here. Yes. That was, we couldn't have done it without them going to the court and doing all of that very difficult, heavy lifting.
Any discussion?
Yeah, just a question. So is there a question on whether the evidence of Swafford review is of low quality? That's the first question.
The question is whether what he was given is reproduced at a level of quality that he would be able to actually comment on what was done. If he had been given a better quality image, then he may have a different view, is the argument. That basically they were looking at apples and oranges, if that's the way to say it.
The industry standard is reproductions at 1,000, I forget, PPI. And this original image, it turns out, was at 350 or something like that.
But I mean, is the question that image was at 350?
I don't think there's a question. The original he looked at was at 350. So now we're reproducing it, and we're gonna see if it makes a difference.
So there's two separate questions. If Henry was looking at it at 350 and the industry standard is 1,000, is that what happened? And we think it likely is. And then the second question is, does it matter? Does it matter? Would Henry's viewpoint on it change at all if he had received the 1,000 standard quality or not? And what Dr. Langenberg is telling us is that it may or may not matter. And that's what he's going to be looking at.
Any other questions? All right, thank you.
I have the next one.
All right, item 13 is an update on the investigative panel for Bodie Technology.
So this disclosure came to us, and it basically involves an unauthorized signature applied by a DNA analyst to some serology reports. They started looking at old files, and they found 3 more possibilities that they were going to investigate. And so we've been waiting for them to finish the evaluation of those other cases and give us that information, and then we can proceed with the investigation. I think they have just completed it. They gave us something. We're going to get some additional materials from it. That's the status.
Okay. Anybody else have any questions regarding that? Okay. Next is item number 14, discussion of the current forensic development training and education projects.
So on Thursday and Friday of next week, we will be meeting with the DNA technical leaders across the state at the CHI in Fort Worth to discuss suitability of DNA mixtures for interpretation. And it's a 2-day meeting. We are funding people to attend, and it's a very full agenda. And so we're looking forward to that. We think it's going to be a great training, and I think our hope is that we will host those trainings twice a year. One will be in person, and one will be via Zoom or another remote conferencing platform. All of you who have labs know that some of your people are attending that, so we're excited about offering that. That's one of the initiatives that Mark Smith has been shepherding through. You met him all when we met at Swift's last. The next thing that we will move on to after that is the DNA training for lawyers and judges that we've been working on with Judge Hervey. She sends her regrets for not being here. She's out ill this week. But Judge Hervey has been great in guiding sort of her thoughts on what would benefit both the bar and the bench. And so I think we will have a great program. One of the dilemmas with planning a program like that is whether it makes sense and whether we can offer a hybrid program that allows people to be in person or watch it online that is going to be of high quality. Hybrid programs are the hardest ones to put together. So often people either do all online or they do all in person. But I know there are so many prosecutors and defense lawyers who really would like this training. So we have this competing set of interests. One is trying to get it out as to many people as possible, and the other is making it in an environment where people are really engaged. Lawyers have short attention spans. I know that might come as a shock to a lot of you, but they
Those are
don't.
defense lawyers.
Not at all.
Those are defense lawyers. That is not prosecutors.
Comment down there. Did that originate in Brazos County? No?
The question is, if we do a totally online platform, will the attorneys watching get as much out of it, considering it's a scientific presentation, than if they were there in person? So y'all may have opinions on that. I don't know.
My first thought is, in order to do this, yes, it'd be better to do it in person, but you're not going to get everybody there in one spot to make this happen. You're going to have to be pulling this like a rolling presentation. You would need to be working with the state bar. You need working with TDCAA. You need to be working with other conferences where you can go to the annual and then go to other sort of big conferences to get that. To me, the first main thing is just to get it out. And if you're doing it via Zoom or via online, then a number of people can chime in if they're interested, they want to be there, and then roll it out and do it live a little bit later on. But I think there'll be a lot of people who are interested in listening online to learn more about this, who can't make it, but they can definitely be in their offices. I know I would just if I could, shut everything down and say you need to be listening to this particular thing because it's that important.
Mm-hmm. Well, one of the things we thought would be helpful is, if we have attorneys there who help with coordinating training for what Judge Hervey calls her grantees, so that's going to be like TCDLA, TDCAA, the Center for the Judiciary, then we could even talk about collaborative opportunities there. One of the things we are going to do is breakout sessions, prosecutors and defense attorneys, because people may want to talk strategy around DNA analysis. Most of it is not going to be breakout. Most of it is going to be commonly understood concepts that everyone needs to know, regardless of who they, which side of the adversarial system they are on. And Judge Hervey, I think, feels very strongly that this information needs to be given to everyone, and that it's not particularly helpful to only hear it in your own camp, so to speak. So we want to make sure that we have a balance there.
I 100% agree. I mean, to me, it's just the knowledge of the science is so important for everybody to have, so that there's not an opportunity for injustice to occur. Just so that everybody raises their level of knowledge on the subject. So,
We will update you more on that at the next meeting. With respect to the ex parte Cologne report that the commission issued, we did an online training. It was very well received. The lab directors and quality managers asked us to send them a copy of the recording so they can present it internally in their laboratories. That is something that has gone out recently. For the labs that are listening, we are going to work on making the Zoom transcript more faithful to the words that were actually spoken. So for right now, the transcript is not all that accurate because it's electronically generated, but we will work on getting that updated. But otherwise, the recording, it works, and you can all use it in discussions with your staff. The next item is that I will be presenting to the Texas Center for the Judiciary on February 13th. They have their annual criminal justice conference. It is an hour, so I'm going to do everything I can to educate the judges on the work of the commission during that hour. It's not a very long time, but Jarvis, to your point, maybe we could work with them later on to do a DNA specific training for judges who are interested. With respect to OSAC implementation initiatives, this is usually something that Dr. Kerrigan updates us on. They are still working on all of the gap analysis, checklist documents, and so she will probably give an update regarding that at the next meeting. We are sponsoring a laboratory manager class through the National Forensic Leadership Academy. We're excited about that. It will probably happen in the summer. The idea that we have is to try to run a Manager 1 and Manager 2 class. Whether they have capacity to do that for Texas, I'm not sure right now. We certainly have the demand. I think HFSC and DPS, even though they've already sent some of their people through that program, DPS at least has, I think maybe even DPS alone could fill an entire class of 30. So we need to figure out a way to keep this as an ongoing offering so that the labs are able to put their people through that. So we think that's going to be a good collaboration with the NFLA. Regarding the 88th legislative session, there are no bills right now pending that directly impact the work of the commission. However, in the next agenda item, which is an update from Dr. Stout from the Texas Association of Crime Lab Directors, he may have some information for you with respect to legislation that impacts the forensic community more broadly. So I don't have anything else for 14 or 15, Dr. Bernard.
All right. Dr. Stout, you're on the clock.
Every time. Good morning, y'all. Yeah, so we had our Texas Association of Crime Lab Directors meeting yesterday. It is the legislative session started the 10th, so we're under the 60-day rule right now, meaning there's lots of bills getting filed, but nothing's being voted on or heard. I've got about 70 bills that I'm tracking right now. So what and Lynn's on our distribution list. What I've agreed with TACLAD is I will send a list of what bills we've got basically weekly. There are at least a dozen bills that look to be a carve out for fentanyl, or fentanyl test strips is kind of the generic term for it, but those materials that can be used, because right now they're paraphernalia, so they're illegal for somebody to have. I think there probably is something that's going to happen with that. There are 6 or 7 bills that have to do with hemp. None of them look like they're going to improve anything. They're probably going to break it further. I hate hemp. Yes, yeah, there are a couple of other bills that I need to start reaching out to members on that have some problematic language. There's one in there that's a refile from last session that the best I could read of it would back laboratories into having to test every item for fentanyl. So you get a box of 20,000 pills. Guess what? You're going to have to test all 20,000 with the way it's written. Obviously, what could possibly go wrong with that? There's some others. There's one bill that was just filed that would prioritize the prosecution of homicides. For the laboratory side of things, our concern is going to be, okay, there's also laws that tell us we have to prioritize testing sexual assault kits, so which awful heinous thing do you want us to put first? Not quite sure how we decide that, but I will get, actually both bill authors are in Houston, so I think I've got a line to reach out to them. There are some federal things that are knocking along. I hopefully have got a meeting with Sheila Jackson Lee's office, probably week after next, to try and follow up on some of the federal end of things. So it's going to get exciting. This year we did make an effort. So Kayla Washington back there is a legislative research assistant that I hired on at HFSC to help me out this session. So you may see her pop up in emails and on stuff along the way there. But that's kind of where we're at. Is there any questions I can answer on legislative stuff?
Is there any general idea of what the feds would be proposing? You said there's some things out there, but is it anything in specific?
Yeah, one of the things that apparently is out there is the next iteration of the Federal Farm Act is out there. Barry was just telling me about this. Oh, Barry's still back there. That they just can't help themselves, and they got to try and change what the concentration of Delta-9 THC is, because that won't cause any chaos. We're all going to stand by and see what that does. There has been some discussion, and I need to see where we're at, appropriations language around the Capacity Enhancement Backlog Reduction Grants and Debbie Smith Act. There were some changes there. I think there were some discussions around just the appropriations relative to forensics in general. I know there was discussion about Coverdale moving up to about 50 million, whole 50 million for the whole country. You know, we get to elbow each other for the quarters and the pennies and the seat cushions on some of these things, but I'll follow up on those. I've heard something that there are some things that point at some of the genetic genealogy stuff that I need to research more at the federal level. Yeah, which, yeah, that one, honestly, I think stand by on that, because clearly there's an awful lot of interest in genetic genealogy stuff, and there's a whole lot of pitfalls there that I'm not sure everybody appreciates yet.
Is there any legislative, whether federal or state, legislation dealing with Delta 8?
The short answer is yes.
Is it good or bad?
Longer, more nuanced answer is no, I'm not sure anybody actually knows what they're doing with that. I have seen some, Charles Perry actually has a Senate bill that tries to create a definition of tetrahydrocannabinoids and synthetic tetrahydrocannabinoids. Yeah.
Is there any, from what you know, is there any field tests? Because my officers are asking us that can distinguish between Delta 9 and Delta 8. Okay.
No, I mean there's barely laboratory tests that can distinguish all of this, and under no circumstances can I distinguish Delta 8 THC that was derived from CBD that came from legal hemp versus Delta 8 THC that came from something else.
Got it.
Yeah, and all of this, I mean, you probably are aware, the trend towards what is becoming called hemp-derived THC, and yeah, under Texas law, I mean, there's the Health and Safety Code and the Controlled Substance Act are basically inherently in conflict over Delta 8 and some of the other Delta 10, THCO, THCP, THCVs. I can't tell you if they're legal or not.
In terms of testing for THC, like your vape cases that you see, does that take longer for you to test than, say, your regular controlled substances, meth, heroin, things of that nature?
Yeah. If nothing else, like on vapes, it's just tough to get into the stupid things. But they are vastly more variable in the material themselves. it is, yeah, all of it is just more complicated. And well, I saw DPS had a memo that they're doing, and Brady, you all are doing vape oils now? Liquids and oils? And plant material. But the, socks, condoms, everything else under the sun, gummies that are infused with cannabinoids is still a huge issue. Yes, the truly stupidest product I have seen is a $285 CBD infused jog bra, but
I'm gonna save all my comments for later.
Well, that went away from our update.
So Texas Association Crime Lab Directors, probably the biggest updates I got there is TACLAD is now actually a listed not-for-profit organization. We are, in fact, a real thing. We have a website now at taclad.org. So we've made some progress on that. We are working on some bylaws changes that we will establish a treasurer, start collecting dues, and we're going to actually be a real organization here shortly. And I think another major update there is Erica Zemek, who used to be our quality director and is now a new addition up at the Chai as their new director of special projects. Congratulations, Erica, but she is now the new secretary for TACLAD. Any questions I can answer for y'all?
Could you talk about the portal a little?
Oh, yes, portal. So that is the laboratory documentation portal. So one of the consequences of the whole Cologne thing is clearly how do we get documents available? It is a serious issue for laboratories in resources to be able to move documentation out, be able to provide documentation. The concept of this statewide laboratory portal where laboratories could move documents to and then manage that out to council is, I think, an important thing. There is money in DPS's LAR. We'll see how that goes through this session. Certainly we'll be talking with Brady a lot about where that stuff's at. I've had a little conversation with Senator Hinojosa's office about some of the language associated with this. It's an important thing. I think the other thing to try and repeatedly make sure everyone is aware is even with that, there still will be resources necessary for laboratories to be able to create the mechanisms to move the documents there. And that's going to be, it's going to have different impacts. I mean, even a laboratory my scale, we've got a long way to go to be able to move documents at scale there, much less some of the small labs. It's going to have very different implications for them.
I think, I'm sorry, go ahead.
We got to get through the session first and see what comes out the other end of that. Because if what actually ends up in DPS's budget is going to be a huge component of then what timelines look like. I actually had a meeting with Versaterm earlier this week and was trying to impress upon them the scale and need of this demand, knowing that the majority of laboratories in Texas are on some version of Justice Tracks product.
Dr. Stout, have you spoken with TDCAA or TCDLA about the portal yet? Because I would imagine they have great interest in this.
I have not. I can reach out to them and start some conversations on that. Because you're right. I mean, I think it will have. I mean, this is little difficult to overstate just how big this is going to be and how essential it's going to be across things. I mean, I know we are seeing a sharp increase in more extensive requests for documentation. I suspect every lab is. Cologne got everybody's attention.
I have a question.
Yes, ma'am.
Is one of the objectives of TCLAD, tackled? I don't know how you. Is one of the objectives to standardize any of the lab processes across labs? Just curious because in sexual assault kits, I know forensic nursing programs all will do things a little differently according to what their crime lab says they want, and so it's been difficult to standardize how evidence is collected. For
Yeah, I think what I can answer there is Texas is very fortunate, one, to have this body, and then also have the Texas Association of Forensic Quality Managers that has recently kind of come into being, and then TACLAD. Really, we've got pretty good communication mechanisms between laboratories in this state. So there's there are more possibilities for us to be able to work at that.
Great. How common is it for states to have a Association of Crime Lab Directors?
Not very, but Texas also has. So I testified to the Senate Criminal Justice Committee at Senator Whitmire's invitation back in December, and one of the things that I brought to them is I'd surveyed the labs, and right now Texas bats somewhere in the neighborhood of about 200,000 requests a year that are processed here, and we're probably looking that there's about 1,500-ish people between all the laboratories here. So Texas has a scale that very few states, maybe California is about the only state that might be kind of similarly scaled of that number of people. So there is a real mass of forensic scientists here to even support such a thing.
Right. Great. Thanks.
Thank you.
Thank you much. Was that short enough for you with questions?
Yeah, reasonably. All right, item 17 is proposed agenda items for the next meeting, which some are carryovers from what we had today. Next meeting is going to be April 14th and July 21st. Is there any public comment? Hearing none. Do I have a motion to adjourn?
So moved.
Have a second? All those in favor say aye.
Aye.
Motion carries. Yeah. It's what they,
July 21st.
it's what they had here. Okay. That's why the desk goes. Yeah, I'm just like.